Hello, future doctors. Greetings. In this presentation, we'll be again discussing different concepts and topics with regards to medical jurisprudence. So let's begin. In the Philippines, before becoming a full-fledged medical doctor, the student must have all the qualification and none of the disqualification of law. So, what are the prerequisites before becoming a physician? First, a person must have a baccalaureate degree with the requisite subject units. In the Philippine setting, a medical student must undergo a 4-year course before entering a medical school. And this undergraduate course must have the necessary subject unit which are required before entering a medical school. So, if these subject units are lacking, a medical student before admission of that medical school must take those subjects, okay? Because they are mandatory. Next, he must have passed the National Medical Admissions Test or NMAT to qualify to be admitted into a medical school. Once again, in the Philippines, NMAT is mandatory. It is a condition sine qua non. Without NMAT, a student cannot enter a medical school. Okay? So, it is necessary to take this entrance examination before enrolling into a medical school. Next, the Doctor of Medicine MD degree is a 5-year graduate program intended to teach students the essentials of being a medical doctor. The program consists of 3 years of academic instruction, 1 year of clinical clerkship, and 1 year of postgraduate internship. Okay? So, in the medical school proper, all the mandatory subjects are being taught. Okay? And the year of instructions are divided. Mostly, first year, second year, and third year focuses on the academic requirements. Okay? For example, like the subject, legal medicine. It is taught in your second year. And then, in the fourth year, a medical student must go into a medical clerkship. Okay? That student must be exposed to the clinical setting. And then after graduation, a medical student must undergo again a postgraduate internship before he or she can take the board examination. Next, after passing the board examination, one can now be considered a licensed doctor. But from there, he is considered a general practitioner. He may also take specialization and sub-specialization. Okay? So, even though you passed the medical examination, okay, the board examination for physicians, it doesn't mean you can already practice different fields of specialization. You must first undergo training. Okay? Once you pass the board examination, you are considered as a general practitioner. So, after passing the board exam, the next step is to choose the field you want to focus your practice. For example, if you want to study internal medicine, you must take a residency, okay, before becoming a consultant in that area. Next, what are the prerequisites for the practice of medicine? Okay? So, the following are another conditions before one can practice medicine. First, the person must be at least 21 years of age. Okay? So, he must be at least 21-year-old here in the Philippines. Next, he must have passed the medical board examination. Next, he must be a holder of a valid certificate of registration issued by the Board of Medicine. Okay? So, passing the board is not automatic. Okay? So, when you pass the board, it doesn't mean you can practice medicine right away. Because there are, again, there are conditions that must be met. Okay? So, the following conditions are discussed in this slide. After passing the board exam, you must apply for a certificate of registration. Question. Once a person has passed the medical board examinations, is the issuance of the certificate of registration ministerial on the part of the Board of Medicine? What do you think? The answer is no. Section 8 of the Medical Act, okay? We have discussed the Medical Act in our previous presentation. It provides that no person shall engage in the practice of medicine in the Philippines unless he is at least 21 years of age and has satisfactorily passed the corresponding board examination. The operative word is satisfactorily. Hence, if the board is not satisfied with the circumstances surrounding the examinee's passing, it has the discretion of postponing or refusing to issue a certificate of registration. The duty to issue such certificate is not ministerial and hence not compellable by a petition for mandamus. Okay? As initiated in the case of PRC versus de Guzman. Like what I've said before, passing the board examination will not automatically grant you, okay, the power to practice medicine. Because the board must first check the entirety, okay, the background of all examinees. For example, before practicing medicine, the examinee must have a good moral character and he must not have committed any crime involving moral turpitude. Okay? So, that alone is a continuing requirement. So, when an examinee is not of good moral character after passing the board examination, then it is up to the board, okay, of medicine, okay, it is based on their discussion, okay, that a certificate of registration will not be given to that person. Now, it begs the question, what are the qualifications candidates for board examination must possess? First, you must be a Filipino citizen. However, if you are a foreigner, first, you must prove that your country allows reciprocal rights to Filipinos in practicing medicine. Okay? So, if you are a foreigner and is planning to take the board exam here in the Philippines, you must first prove that your country allows Filipino citizen to practice medicine. Second, you must be of good moral character. So this requirement is a continuing requirement. Even if you pass the board examination, even if you practice medicine, even if you become a licensed doctor, you must have a good moral character always. Okay? So, if you don't have a good moral character, your certificate of registration can be revoked. Okay? It can be suspended. Next, you must be of sound mind. Next, not convicted of a crime involving moral turpitude. Another requirement must be a holder of the degree of Doctor of Medicine. Next, he must have completed a calendar year of technical training known as internship. Okay? So, in this stage, you have already graduated, okay, a 4-year course in the School of Medicine, and then you are taking the postgraduate internship. So those are the requirements before taking the board examination here in the Philippines. Now, you have passed the licensure examinations for doctors, and then you are already given a certificate of registration from the Board of Medicine. And then you are now planning to practice medicine. It begs the question again, what constitutes the practice of medicine? Okay? So, the practice of medicine entails the following. First, to physically examine and diagnose a patient. Okay? You must physically inspect the patient and then diagnose his or her disease. Next, to physically examine and treat a patient. Next, to physically examine and perform surgery in a patient. And then lastly, to physically examine and prescribe any remedy to a patient. Okay? So, practice of medicine involves the diagnosing a patient, treating a patient, okay, performing surgery, prescribing medication. Okay? A person shall be considered as engaged in the practice of medicine if he or she, for compensation, fee, salary, or reward in any form paid to him directly or through another, or even without the same, physically examine any person and diagnose, treat, operate, or prescribe any remedy for human disease, injury, deformity, physical, mental, or psychological condition, or ailment, real or imaginary, regardless of the value of the remedy administered, prescribed, or recommended. So, generally, the practice of medicine entails prescription, okay, prescribing of drugs, examining the patient, diagnosing the patient, treating the patient, okay. It also entails compensation. The doctor is being paid, okay, a reward in any form, paid to the doctor directly or indirectly, okay. Another act of practicing medicine is by means of signs, cards, advertisements, written or printed matter, or through the radio, TV, or any other means of telecommunication, either offer or undertake by any means or method to diagnose, treat, operate, or prescribe any remedy for any human disease, injury, deformity, physical, mental, or psychological condition. Okay? So if a person advertises himself or herself to be a doctor, then he is practicing medicine. And then falsely use the title of MD after his name. Okay, so if you place MD after your name, it means you are already practicing medicine. Now, let's discuss a case. As enunciated in the case of PRC versus de Guzman, Supreme Court said, until the moral and mental fitness of the respondents could be ascertained, according to petitioners, the board has discretion to hold in abeyance the administration of the Hippocratic Oath and the issuance of the certificates to them. The writ of mandamus does not lie to compel performance of an act which is not duly authorized. Okay? So, the power of the Board of Medicine, okay, upon passing of an examinee, when an examinee has already passed the board examination for physician, it is not a ministerial duty of the board to give the certificate of registration to them directly. Okay? So, it is still discretionary. Okay? The board still has to check the background of the examinee even though he has already passed the board examination. Okay? It is within the power of the board to ascertain and examine the examinee whether or not he has the moral compass, okay, whether or not he has still all the qualification and none of the disqualification of law. For example, having a good moral character, okay, and then another, what if the examinee has committed a crime involving moral turpitude, okay, during the pendency of his or her Hippocratic oath, okay. By the way, the Hippocratic oath, okay, the taking of oath is the last act, okay. It is very important because if a person who passed the licensure examination for physician does not take the Hippocratic oath, then he is not a full-fledged doctor, okay? Because the taking of the Hippocratic oath is the last step, okay, of becoming a medical doctor. However, still, the duty of the board of medicine is not ministerial. Okay, you cannot compel them through a writ of mandamus to give you a certificate of registration because still the board of medicine will determine whether or not a certificate of registration will be given to you based on the following conditions prescribed by law. Next, what are the grounds for reprimand, suspension, or revocation of a physician's certificate of registration? Okay? So, once a physician has passed the board examination and he is also likewise given a certificate of registration, then he can now practice medicine for all intents and purposes. However, if a physician commits a mistake or if a physician does not comply with the requirements of the law, of the continuing requirements, for example, being of good moral character, then he can be administratively liable. Okay? So, reprimand, suspension, or revocation of certificate of registrations are the administrative sanction, okay, to the erring doctors. So, what are the grounds? First, conviction by a court of competent jurisdiction of any criminal offenses involving moral turpitude. Next, immoral or dishonorable conduct. Another ground, when a doctor becomes insane. Another, fraud in the acquisition of the certificate of registration. Okay? Next, gross negligence, ignorance, or incompetence in the practice of his or her profession, resulting in an injury to or death of the patient. Okay? So, for example, criminal negligence. Okay? Medical malpractice. Okay? These are the instances. Next, addiction to alcohol beverages or to any habit-forming drug, rendering him or her incompetent to practice his or her profession, or to any form of gambling. Okay? So, um, these behaviors, these acts are related to the character of the physician, because being a physician, being a medical doctor is a noble, okay? It is a noble profession, okay? So, if you are a doctor, you must live an honorable life, okay? You must live a life worth emulating by others. Um, your character must be beyond reproach, okay? Now, another ground for administrative sanctions is the false or extravagant or unethical advertisements, wherein other things than his name, profession, limitation of practice, clinic hours, office, and home address are mentioned. Okay? So, very common. Okay? Those doctor who has very high regard to themselves and tends to mislead, okay, the patients, or destroy the character of other doctors. For example, if a certain physician advertises false advertisement like, I am the best doctor in the world, okay? If I will treat you, your disease or ailment will be gone in an instant, just like magic. Okay? So, that is a classic example of extravagant and unethical advertisement. So, you can be administratively sanctioned because of that. Another is performance of or aiding in any criminal abortion. So, in the Philippines, abortion is illegal. So, if you are a physician and you aid or abet in criminal abortion, then your license can be removed. Next is knowingly issuing any false medical certificate. Okay, this is very common in our setting. If, for example, a student wants to go somewhere and does not want to attend class, then he will just present medical certificate that he is sick that time. Okay, very common. However, it is these acts can be sanctioned by the Board of Medicine. Okay, you can be, if you are a physician, you can be reprimanded, or your license can be revoked, okay, or suspended. Another act is issuing any statement or spreading any news or rumor which is derogatory to the character and reputation of another physician without justifiable motive. Okay? So, very common. Character assassination to other doctors, okay? So, that is an illegal act, and you can be administratively sanctioned. Next is aiding or acting as a dummy of an unqualified or unregistered person to practice medicine. Another act is the violation of any provision of the Code of Ethics as approved by the Philippine Medical Association, like refusal of a physician to attend a patient in danger of death is not a sufficient ground for revocation or suspension of his registration certificate if there is a risk to the physician's life. Okay? So, if you fail to help a person who is in danger, okay, in a case of emergency, then you can be reprimanded. However, if it caused risk to your life, then it is excusable. Next, what are the threefold liabilities of a physician, or otherwise known as the three-pronged liabilities? Okay, so these are the following. First is administrative liability. So these are liabilities which um, you can file to the different government agencies. Okay, for example, the PRC or the Philippine Regulatory Commission, or to the Board of Medicine. So, the sanction of which are the following: reprimand, suspension of license, or revocation of license. Next is the civil liability, which you can file in Philippine courts, okay? And it depends on the value. For example, if the value is lesser, you can file it in the municipal trial court, or if higher, in the regional trial court. Um, in civil liability, it contemplates damages. So, by damages, um, the physician or doctor must pay the patient in a form of damages or monetary award. So, that is why the value is taken into consideration. Next and lastly is the criminal liability, where the physician or doctor can be imprisoned due to his illegal acts. What are the administrative liability of a physician? Okay? So, a practice of medicine is a privilege and not a right. Hence, it could be taken away from the physician. In administrative liabilities, a physician's profession is temporarily withdrawn from him to protect future patients. Okay? So, like what I've said before, um, these administrative liabilities are weapons, okay, in order to prevent the physician to do further harm to patients, and the penalty of which are reprimand, suspension, or the revocation of license. So what is the quantum of evidence required in order to penalize a physician? It only needs substantial evidence. So, jurisdiction: the Board of Medicine, the Professional Regulatory Commission for quasi-judicial body, and the Philippine Medical Association. Okay? So, these are the different government agencies where you can file your complaint. Example: non-compliance of national and local laws, which includes sanitary code, fire code, and etc. Okay? Another classic example is if the physician commits medical malpractice, then you can file an administrative complaint directly to PRC, okay, to remove or revoke his or her license. Next is the criminal liability for acts or omissions constituting a crime. Acts or omissions constituting a crime can be done with deceit or deliberate intent, or fault or negligence, imprudence, lack of skill, and lack of foresight. So the penalty is imprisonment or fine, okay, in special laws. And then the quantum of evidence required is proof beyond reasonable doubt. And the proper jurisdiction are the regular courts. So in criminal liability, the doctor, if proven guilty, can be imprisoned. Okay, not only his license be revoked, but he can be put to prison. Next is the civil liability. Civil liabilities make a physician liable to compensate the patient for the injury he suffered on account of his wrongful act or breach of contract. It may include moral or punitive damages, okay? So in civil liability, it contemplates monetary liability, okay? Compensation to patients for the wrongful done. So penalty are damages, okay? Payment to the patient. Quantum of evidence required is only preponderance of evidence. And again, you can file your claim to the regular courts. Now, let's go to the illegal practice of medicine. What does it mean to illegally practice medicine? Okay? So, practice of medicine by any person not qualified and not duly admitted to perform medical acts in compliance with law. So, what are the penalties if you illegally practice medicine? Okay? First, pursuant to Section 28, Article 4 of the Medical Act of 1959 as amended, any person found guilty of illegal practice shall be punished by a fine of not less than 1,000 pesos or more than 10,000 pesos with subsidiary imprisonment in case of insolvency, or by imprisonment of not less than 1 year, nor more than 5 years, or both. Such fine and imprisonment in the discretion of the court. Okay? The Medical Act is very old law but still relevant in today's time, because it is still the basis, okay? This organic law is still the basis of the practice of medicine. Without this law, there is no medical profession. Now, it begs the question, who is a physician? A physician is the person who, after completing his secondary education, follows a prescribed course of medicine at a recognized university or medical school, at the successful completion of which is legally licensed to practice medicine by the responsible authorities, and is capable of undertaking the prevention, diagnosis, and treatment of human illness by the exercising independent judgment and without supervision, okay, according to the World Health Organization. So in the Philippine setting, a physician is a person who has all the qualification and none of the disqualification as prescribed by the Medical Act. Now, let's go to medical malpractice. What is medical malpractice? It is the failure of a physician to properly perform the duty which devolves upon him in his professional relation to his patient, which results to injury. It may be defined as bad or unskillful practice of medicine resulting to injury of the patient or failure on the part of the physician to exercise the degree of care, skill, and diligence as to treatment in a manner contrary to accepted standards of medicine resulting to injury to the patient. Okay? So in medical malpractice, there is a standard of care that a physician should follow. However, there is a breach of that standard, and due to that breach of the standard, it caused injury to the patient, and this injury can be compensable through damages. Okay, so such injury, the proximate cause of which is the breach or the violation of that standard of care by the physician. Okay, so medical malpractice is very common in the hospital setting. Now, what are the elements of medical malpractice? Okay, so first, the physician has a duty to the patient. There is a standard of care which the physician is duty bound to do. Next, the physician failed to perform such duty to his patient. Okay, so there is breach of that duty. There is a violation of that duty to his patients. And as a consequence of the failure, injury was sustained by the patient. Okay, the proximate cause of the injury of the patient is the non-performance or the failure of the doctor to perform the duty to his or her patients. And then the failure of the physician is the proximate cause of the injury sustained by the patient. Okay. Now, what is criminal medical malpractice? So it is an act or omission complained of must be punishable by law at the time of commission or the omission. So these are acts which are punishable by law. Okay. So at that time, there is a law punishing that act. That's why it's called criminal medical malpractice. To be considered medical malpractice under the law, the claim must have the following characteristic. Okay? So, a violation of the standard of care. The law acknowledges that there are certain medical standards that are recognized by the profession as being acceptable medical treatment by reasonably prudent healthcare professionals under like or similar circumstances. Okay, so there is a basis, a standard of care, and the doctor or physician is duty bound to follow that standard. However, due to the breach of that standard of care, it causes injury to the patient. That is why it is considered a medical malpractice. This is known as the standard of care. A patient has the right to expect that healthcare professionals will deliver care that is consistent with these standards. If it is determined that the standard of care has not been met, then negligence may be established. An injury was caused by the negligence. For a medical malpractice claim to be valid, it is not sufficient that a healthcare professional simply violated the standard of care. The patient must also prove he or she sustained an injury that would not have occurred in the absence of negligence. So in court, cases are based on facts, okay? It is factual in nature. That's why you need to prove it. You need to present evidence. you need to present proof in order for you to win in court. Okay? So, an unfavorable outcome by itself is not malpractice. The patient must prove that the negligence caused the injury. If there is an injury without negligence or negligence that did not cause an injury, then there is no case. Okay? So, the injury resulted in significant damages. Medical malpractice lawsuits are extremely expensive to litigate, frequently requiring testimony of numerous medical experts and countless hours of deposition testimony. Okay? So, a medical malpractice suit is very expensive. Okay? For a case to be viable, the patient must show that significant damages resulted from an injury received due to medical negligence. If the damages are small, the cost of pursuing the case might be greater than the eventual recovery. To pursue a medical malpractice claim, the patient must show that the injury resulted in disability, loss of income, unusual pain, suffering, hardships, or significant past and future medical bills. Okay? So, if you are a doctor, you can be civilly liable. Okay? Payment through damages. A monetary award can be given to the patient if you have violated a standard of care. Okay? There is breach of that standard. So, if there is breach of that standard and it causes injury to the patient, then you have committed medical malpractice. However, monetary award is not enough, okay? Because like what we have discussed before, there are three-pronged liability, okay? That the patient can seek redress. For example, the administrative agencies of the state, okay? The patient can file administrative complaints where a doctor can be suspended or revoked. The license of the doctor can be cancelled. Next, the civil liability, of course, it contemplates monetary award. And lastly, the criminal liability where the doctor can be imprisoned. Now, the following are examples of medical malpractice. Failure to diagnose or misdiagnosis. For example, a doctor is incompetent. Okay, he did not study the case properly of the patient and it led to misdiagnosis. Of course, it is injurious to the client if you misdiagnose his or her disease. Next, misreading or ignoring laboratory results. And then unnecessary surgery, okay? Especially to unscrupulous or unprincipled doctors who only wants money. They perform unnecessary surgery to clients or patients. Then surgical errors or wrong site surgery. Incompetent doctors who wrongfully operate. Okay. Next is improper medication or dosage. Very common in the hospital setting whereby medications are exchanged due to, for example, it's very busy in the area or the dosage was not properly read by the doctor. Next, poor follow-up or aftercare. Premature discharge, disregarding or not taking appropriate patient history. Failure to order proper testing and failure to recognize symptoms. Okay? All of this redounds to the competency of a physician. So that is why as medical students, you need to study extensively, okay? work hard, research every day, improve your knowledge, improve your skill, and then improve your attitude. Now, let's go to definition of terms. What is duty? A duty is simply a legal obligation. In order to be sued for negligence, the defendant must have owed a duty to the plaintiff. Okay? So, of course, in medical malpractice, there is a standard of care. And it is the duty of the physician to uphold that standard. Next is breach. A breach is a violation of a law or duty. The defendant must breach his duty in order to be liable for negligence. Okay? So, breach is the violation of such a standard of care. And the next term is cause. The breach of duty must have caused harm to the patient or the plaintiff. Next word is harm. The plaintiff must suffer harm in order to sue for negligence. If he suffers no harm, then he cannot sue. And then tort. A tort is an act or omission that gives rise to injury or harm to another and amounts to a civil wrong for which courts impose liability. In the context of torts, injury describes the invasion of any legal right, whereas harm describes a loss or detriment in fact that an individual suffers. Now, what is the Statute of Limitations? Statutes of Limitations sets time limits for plaintiffs' civil actions. The rationale is to provide some measures of assurance to potential defendants so that they need not fear impending lawsuits indefinitely. Okay? So, if a patient, okay, has a right to sue a doctor, then that patient is given time in order to file his claim to the court. Otherwise, if he will not file, okay, he will sleep on his or her right, then the statute of limitation will set in. Further, with the passage of time, evidence may be lost and memories fade, making the trial process less reliable. Now, let's go to another principle of law, contributory negligence and assumption of the risk. As medical malpractice cases are tort claims, affirmative defenses available to a defendant in a standard civil claim are likewise available in a malpractice suit. Okay? So, these are the defenses. If you are a physician but a malpractice case suit is filed against you. So these are your defenses that will lessen or relieve your liability. Prominent among these defenses are contributory negligence and assumption of the risk. So these defenses rest on the rationale that even when a defendant is negligent, a plaintiff may assume some or all responsibility for an injury when she contributes to the harm or knowingly engages in activities likely to lead to harm. So these concepts contemplates that the patient itself contributed to the harm, okay? Contributed to the negligence, okay? So that patient assumed the risk. Next concept is the Good Samaritan law. Physicians are under no obligation to treat people simply because they need medical assistance, but are open to liability for negligence if they do provide treatment negligently. even if the physician is not being paid. As such, there is a strong incentive for physicians not to treat people outside of the course of their regular practices, even in cases of emergency. Okay, so this is a defense whenever a person was harmed due to your care. Okay, however, it was done during emergency. Okay, where the patient does not pay or there was no physician-patient relationship. So, Good Samaritan law can be used as defense to lessen your liability. Now, let's go to the different defenses to medical malpractice. A physician facing a medical malpractice lawsuit can defend against the claim by arguing that the plaintiff failed to show by preponderance of the evidence that the physician's conduct met the elements of a malpractice claim. Okay, so like what we have discussed before, medical malpractice has its elements. Okay, so one of its defenses is to prove that those elements are absent. Okay, alternatively, the physician can argue that the circumstances of the lawsuit procedure preclude a finding of liability, regardless of the persuasiveness of the plaintiff's case. These affirmative defenses are available to defendants in civil suits generally, though physicians facing malpractice claims have some additional recognized defenses. Now, let's go to the concept of proximate cause. What is proximate cause? That cause which a natural continuous sequence unbroken by any efficient intervening cause produces the injury and without which the result would not have occurred. So, there must be a direct physical connection between the wrongful act of the physician and the injury sustained by the patient. The cause or the wrongful act of the physician must be efficient and must not be too remote from the development of injury suffered by the patient. The result must be natural, continuous, and probable consequences. Okay, so these are the definition of proximate cause. Another principle of law is the doctrine of efficient intervening cause. In the causal connection between the negligence of the physician and the injury sustained by the patient, there may be an efficient intervening cause, which is the proximate cause of the injury. Okay? So, by definition, it means that it is not due to the negligence of the physician where injury, okay, where harm to the patient occurred, okay, but by other some intervening causes. Another concept of law is the doctrine of vicarious liability. So the doctrine of imputed negligence or the command responsibility, okay, other terms. Vicarious liability means the responsibility of a person who is not negligent for the wrongful conduct or negligence of another, okay? So classic example of vicarious liability are whereby superiors, okay, of doctors are also held liable to the harm done to patients, okay, like hospital owners, supervisors, managers, okay, they can be accountable due to the negligence of their staff. So that is why, because it is the duty of those heads to choose their competent staff. That is why they can also be held liable. Another concept is the captain of the ship doctrine. This doctrine enunciates liability of the surgeon not only for the wrongful acts of those who are under his physical control, but also those wherein he has extension of control. Okay? So, this is also by virtue of respondeat superior. If you are the superior, if you are the captain of the ship, then you are also liable to all acts of your staff, okay, who are under you. Doctrine of res ipsa loquitur. So this is a Latin term which means the thing speaks for itself. So the nature of the wrongful act or injury is suggestive of negligence. General rule: expert testimony is necessary to prove that a physician has done a negligent act or that has deviated from the standard of medical practice. Okay? So, like what I've said before, in court, it would be factual. Okay? It would be a matter of evidence. You have to prove all circumstances, all facts which surrounds the case. What are the requisites of res ipsa loquitur doctrine? First, the accident must be of a kind which ordinarily does not occur in the absence of someone's negligence. Okay? So, in the ordinary course of things, the accident must not occur. Okay? It must be caused by an agency or instrumentality within the exclusive control of the defendant. Third, it must not have been due to any voluntary action or contribution on the part of the plaintiff or the patient. Now, these are some cases where the doctrine of res ipsa loquitur has been applied. Objects left in the patient's body at the time of cesarean section. Okay? So, very clear. The physician has committed a medical malpractice. The thing speaks for itself. A object, okay, was left in the patient's body due to the negligence of the physician. Next, injury to a healthy part of the body. Another, removal of a wrong part of the body when another part was intended. Next, infection resulting from unsterilized instruments. Another, failure to take radiographs to diagnose a possible fracture. Okay, so these situations would the patient can file a claim against the doctor. In the other hand, let's go to instances where the doctrine of res ipsa loquitur does not apply. Okay? Where the doctrine of calculated risk is applicable. Okay? So, remember the defenses that we have discussed. The assumption of risk. Okay? If those are applicable in a situation, then the doctrine of res ipsa loquitur will not apply. Next, when an accepted method of medical treatment involves hazards which may produce injurious results regardless of the care exercised by the physician. Another is the bad result rule. Okay? If a doctor, when he has explained all the pros and cons, okay, to the family or to the patient, and operation is the only last resort and the outcome is unpredictable, then it is considered a bad result rule. then doctrine of res ipsa loquitur will not apply. Next, honest errors of judgment as to appropriate procedure. And then mistake in the diagnosis. In most medical malpractice suits, there is a necessity for a physician to give his expert medical opinion to prove whether acts or omissions constitute medical negligence. So again, if your claim is filed in court, if you are the patient, you need to prove all facts and circumstances surrounding the case. So you need to present evidence, you need to present expert witness, okay, in order to gauge whether or not the physician was negligent in his acts. This doctrine has been regarded as rule of sympathy to counteract the conspiracy of silence. Now, let's go to the concept of damages, okay? The final element of a medical malpractice suit is damages, which are the harm caused to the patient by the doctor's breach of duty, as enunciated in the case of Wright versus St. Mary's Medical Center of Evansville. Generally recognized damages include out-of-pocket costs such as medical bills, loss of income, financial loss due to permanent impairment, and monetary value assigned to pain and suffering. These all qualify as compensatory damages. Okay? So in the Philippine setting, there are also types of damages. For example, actual damages. Okay? Compensatory damages, temperate damages, okay, and other damages. Moral damages, if a person has experienced sleepless nights, wounded feelings, anxiety, okay, then it is also a form of damages. In addition to compensatory damages, plaintiffs in civil actions may also recover damages beyond compensation for harm in cases of gross negligence by the defendant. These punitive damages are means of punishing defendants for engaging in egregious behavior in cases of conscious indifference to the welfare of the plaintiff or willful and reckless conduct. Now, another principle of law is informed consent. What is informed consent? Okay, so this is an illustration whereby the informed consent is being illustrated by the doctor, okay? Which therapy would you prefer, okay? The act of the doctor of explaining to the patient the pros and cons of an operation or surgery, okay? So if the person agrees, he will sign an informed consent form. What is informed consent? It is a process of understanding the risks and benefits of treatment. It is based on the moral and legal premise of patient autonomy. The patient has the right to make decisions about his or her own health and medical conditions. Permission granted in knowledge of the possible consequences, typically that which is given by a patient to a doctor for treatment with full knowledge of the possible risks and benefits. Okay? So, informed consent is very important, especially during operation. Because if something happens to the patient, this document can be used as evidence, okay, by the doctor. in order to protect his or herself. What are the components of informed consent? There are 4 components of informed consent. The patient must have the capacity or ability to make the decision. The medical provider must disclose information on the treatment, test, or procedure in question, including the expected benefits and risks and the likelihood or probability that the benefits and risks will occur. The patient must comprehend the relevant information. The patient must voluntarily grant consent without coercion or duress. Okay? So, informed consent contemplates that the patient understands all the risks, okay, that comes with the operation, and he agrees to such risk. What are the subject matter of informed consent? The following are the required elements for documentation of the informed consent discussion. First, the nature of the procedure. Second, the risks and benefits and the procedure. Third, reasonable alternatives. Fourth, risks and benefits of alternatives and assessment of patient's understanding of elements 1 through 4. What is the purpose of informed consent? The purpose of which is to avoid legal action according to the doctrine of informed consent. Physicians must disclose enough information for the patient to make an informed decision. Okay? So, informed consent document is very essential. It can be used as a defense in the court of law. However, because informed consent laws and principles do not specify the amount of information that must be disclosed, physicians might find it useful to know what they must typically disclose. So these are the elements of informed consent. First, research description, and then the risk involved, the benefits, alternative treatments, confidentiality, compensation, contacts, and then voluntary participation and or withdrawal. So what are the kinds of consent? It can be implied consent, express consent, or written consent, informed consent, and unanimous consent. Now, it begs the question, who can give informed consent? Okay, for example, the patient that undergoes an operation is a minor or is unconscious. Who can give informed consent? Competent adults are solely responsible for the determination of healthcare services to which they are willing to consent. Okay? So, if the patient is conscious and able, he can give the consent. Next, informed consent to the treatment of an adult patient may be sought from an authorized person only when the patient is incapable of consenting because of incompetency or incapacity. Okay? For example, the patient is in coma or the patient is insane and so on and so forth. Minor patients are generally unable to consent legally until 18 years of age. Okay? In the Philippines, the age of majority is 18 years old. Now, what are the instances where no consent is needed? First, emergency exception. Okay? Patient cannot consent because, of course, it's an emergency. A reasonable person would have consented. Cannot use the emergency exception if patient refuses care. Okay? So, if the patient is conscious and he refuses care, then, of course, the doctor cannot do anything except abide by what the patient has decided. But however, if the patient is unconscious, of course, he cannot consent, then emergency is an exception. Consent by a guardian or parent in case of minor or incompetent person. Then court-ordered care and some public health treatments like mandatory vaccination requirements, status requiring quarantine in cases of contagious diseases. Okay, for example, like today where there is a pandemic due to COVID-19. Okay, so isolation is mandatory if a person is exposed to the virus. So consent is not necessary because it is already provided for by law. What is competency? Competency refers to the degree of mental soundness necessary to make decisions about a specific issue or to carry out a specific act. Okay? So, competency contemplates about the soundness of the mind. Okay? So, if the person is insane, then he is incompetent to decide. Okay. So, sample informed consent form. Okay, I will show you sample documents of informed consent. So, this is a medical consent form where the patient will sign if he agrees to the operation. So, in case of emergency, blank has my consent to authorize medical care for my children listed below. Okay, so mostly information with regards to the treatment or the operation is filled out in this form. Okay, the risk involved, the operation, the doctor, and the person who is the subject matter of the operation, he must sign, okay, in this document. This document is very important, not just to the patient but also to the doctor, because if there is any adverse effect of the operation, this consent form can be used as a defense. Okay, that the doctor has explained to the patient the risk involved and the outcome is unpredictable. So this is another sample of an informed consent for invasive diagnostic, medical, and surgical procedures. Okay, so this is more detailed compared to the previous one. So, but what is essential, what is needed is the signature of the patient. Okay, and must also illustrate, reflect all the information with regards to the patient and the operation and the risk involved. Okay, so that ends our discussion, and these are the references in today's topics. Okay, today's discussion. So mostly it's found in the internet, some in the books, and of course, as a medical student, you can also find other references in order to study more, okay? Dig deeper, research on those topics which were previously discussed, okay? So, our discussion was merely an overview of the topics. It's up to you, student, to continue reading, okay? Explore other materials. And if you have any question, do not hesitate to communicate with me, okay? You can comment down below for any clarification, okay? So that ends our topic. That's it. Thank you for listening, And God bless us all.